Welcome, everybody. And this is the last webinar for the year of 2024. We cannot, obviously, end the year without a good look at what's coming next. And today we're talking about the US Telecom policy for 2025. It is the right time. The US elections are just over. Republicans have regained the White House as well, the Senate. So what does it mean for the FCC and the policy that will come next? Well, we have some of the most informed people here, and very welcome to introduce you, Glenn Richards, a member of Dickinson Wright, Stephan Corin, the attorney from Lerman Senter PLLC, and Kevin Rupy, the attorney from Wiley. To all of you, a very big welcome, especially to Stephan, because Stephan, it's the first time you come and join us here at MEF. Now, before I go any further, I'm followed by three lawyers. I'm sure that there are disclaimers coming in front of me, right and center. But I'll let you decide what you can or cannot say. Any words of advice to our listeners out there?
I guess standard disclaimer for webinars of this type. The things we discussed today, this does not constitute legal advice. These do not necessarily reflect the opinions or views of our clients or other attorneys in the firm. Opinions are our own. So again, not legal advice. Steve, I don't know if you have anything to add to that.
No, thanks, Kevin. I would just say if you do have questions, feel free to follow up with us or your own counsel or your consultants. And terrific to be joining you all for the first time, and hope to do it again soon if things go well today, and I'm sure they will.
Great. And so welcome, Glenn, as well. No additional words on disclaimer so far, but I've got a disclaimer here. The disclaimer would be, if only we could fix everything that is topic-wise and agenda-wise, which is within the next 2025 in 1 hour, that would be great. There had been some handpicking done on some of the biggest and most interesting topics, but if you don't mind, I'll start the dance with a question on the FCC administrations. We have heard lots of nomination from the new administration, and Brendan Carr is a new commissioner of the Federal Communication Commission in the US. Donald Trump has been decided to replace Jessica Rosenworcel. So you know him, right? Because he's been in the FCC. He's been appointed by Donald Trump before. He's served as the general counsel of the agency for Commissioner Ejipai as well. So plenty of history. What do you think that his priorities, given what you know of him, might be in terms of national security, spectrum, infrastructure, etc.? Who would like to start them? Let's give Stephan, given that you are your baptism of fire, what would you say that Brendan Carr is going to bring to the FCC next?
Well, I think you hit on 3 or 4 of what he's indicated his priorities are going to be, and I'll just go into them a little bit deeper and then let Glenn and Kevin chime in. One is national security, and there is a sort of a common bipartisan emphasis on rooting out cyber criminals and at the same time beating the Chinese to 6G, whatever that means. This is also kind of a congressional priority that's also been bipartisan, and it's been brought to light very recently with the Salt Typhoon revelations and the FCC's recent indication that it's going to adopt a declaratory ruling and impose some obligations on broadband providers to harden their networks or to engage in reporting. The details of that to be worked out, but I don't see that Commissioner Carr is going to, kind of walk away from that. Although his comments yesterday were more focused on coordination with other agencies than they were about the FCC necessarily taking a lead role. The second topic is spectrum, something near and dear to my heart. The FCC has been without auction authority for going on 2 years now, except for a short window when T-Mobile and others were able to get a bunch of licenses through. I think with a Republican House, a Republican Senate, it's more likely that we will see a spectrum bill pop out of the FCC. Senator Cruz has made this a priority. And Commissioner Carr, soon to be Chairman Carr, has also been focused on this. On infrastructure, I think a couple of things, and this has been something that Commissioner Carr has been very interested in since he became a commissioner about 7.5 years ago. And we've seen pictures of him climbing towers. I think his interest in infrastructure goes beyond putting on a hard hat and going 200 feet in the air. I think it involves streamlining the federal permitting process on federal land. It involves, using infrastructure streamlining to rationalize federal funding programs. I think that's something that is going to be front and center. And again, it should not be something that is partisan. And it is something that I think he should be able to move on fairly quickly. The last one I want to just briefly touch on is enforcement. I think the focus there will be on rooting out and penalizing waste, fraud, and abuse. That's a Republican meme, as well as things that are baked into the statute, especially for universal service. And I think that's something that he's going to continue to move forward. We'll talk a little bit later about what some of the reins are and what some of the obstacles are to the FCC's enforcement authority. But I think there are certainly ways to, kind of keep folks towing the line.
Thank you, Glenn. Kevin, would you add anything to those the priorities that Stephen has just shared with us?
So this is Glenn. Hi, everybody. My only disclaimer is don't take anything I say too seriously. I want to get a little more granular on sort of the process. So Trump has announced that he wants to promote Carr, who's a sitting commissioner, to chair. The current chair, Jessica Rosenworcel, has announced her departure for January 20th. The next FCC meeting is actually January 15th. So I think it's important to understand, at least at Carr's first meeting, there's only going to be 4 commissioners, and it'll be 2-2. So he will struggle, at least for some period of time, to the extent he wants to push things through. He has the same constraints that Chair Rosenworcel had, at least initially, which is things will have to be unanimous. So while I think there are certain sort of bigger policy issues where he would like to see undone by the FCC that happened during the Rosenworcel administration, until they have a 5th sitting commissioner, he is sort of in the same position of requiring unanimity amongst the 4 to push things through that are substantive. So how quickly the Trump administration, there's been trade press even this week that he's going to propose a nomination. Ted Cruz, who's going to be promoted to chair of the Commerce Committee, has been allegedly advocating for Ariel Roth, who we know because she used to be a legal advisor. But it's probably going to be 3 or 4 months before she would be confirmed, assuming that's what happened. The other inside baseball conversation is that one of the sitting Republican commissioners, Symington, has at least been quietly suggesting that he may not stay on the commission and may be looking for other opportunities in the administration, which, arguably could be running NTIA, which is where he came from. If he decides to leave, we're sort of in that same position again of, so while Carr may have his priorities, he is going to be, until he's got a majority with, 3 sitting and with 2 Democrats, that may be an issue. But I agree with everything Steve said. I think we have a whole bunch of other issues we're going to get into, which is how the FCC manages issues that are now before the court, all of which Commissioner Carr, soon to be Chair Carr, really railed against in terms of whether it's digital discrimination, net neutrality, a number of issues that were pushed through on party lines by the FCC under Rosenworcel are all now subject to appeal. Once those cases kind of move forward and Carr is the chair, he has difficult decisions to make as to what to tell the general counsel, how to administer those cases, and whether he waits to see what the court's going to do. So there's a lot of interesting kind of moving parts. And the last thing I'll say before I hand over to Kevin is, I've been doing this for 39 years. I've lost count of how many administration changes there have been in that time, but it always makes for, good bar conversation as to what's going to happen. But the cybersecurity issues, I'll agree with Steve, I think are front and center. And whether or not the FCC is even willing to go forward with what's been proposed by the current chair, which at least, Cruz has said is not enough, remains to be seen. So I'll stop there and hand off to Kevin.
Yeah, no, thanks, Glenn. I don't have much to add to that. I mean, the only additional color I'd put in there to Glenn's point about the FCC makeup, during the Rosenworcel administration, I think she didn't get a 3-2 commission until 2 years in. So, as Glenn noted, that can significantly hinder the ability of the chair to implement their policy. And I do think that in terms of, depending, it's a chessboard, who stays, who goes, and depending on how quickly the Senate can confirm those one, possibly two commissioners is going to sort of drive the ability of Chairman Carr to implement these policies. Now, that said, Dario, as you noted at the front end of this webinar, the Republicans ran the board. They've got Congress, they've got the House, the Senate, the White House. So, my assumption is that they will try to move as quickly as possible on all these.
Let me ask something else. So, if I understand correctly, definitely there is somebody with experience as a new chair, but I also hear it's got an agenda. There might be some challenges on the mechanics of how to implement it. But what if it's external to the FCC? What's happening with what I heard as the DOG, the Department of Government and Efficiency in the White House? This administration has got a clear mandate of revolutionize, I would say, part of the administration itself. How is that going to impact, will it impact the FCC and telecom in general? Anybody would like to take it out? I'll go back to Glenn this time. Glenn, what's your view on Elon Musk intervention in telecom policy?
Well, I mean, raises some interesting conflict issues because, Musk has got his Starlink venture, which is clearly kind of front and center and does have issues before the FCC, including the ability of Starlink to qualify to get certain broadband subsidies that are available. So I don't want to suggest there's an inherent conflict of interest given his role, but there's an inherent conflict of interest. But, I think the FCC may be a little bit different here in terms of the efficiency issues. The FCC imposes regulatory fees, which it collects from all the companies it regulates, which I think goes to help fund the commission. I wouldn't, and maybe Steve and Kevin have other thoughts. I don't see the FCC as a bloated agency. I don't see the FCC as sort of logical. It already has field offices in other places. The FCC sort of is Washington, belongs in Washington. I don't think it'll be high front and center of the agencies that they're going to look to either get rid of or move to some other state. And I think that because it funds through its own regulatory fees, I think it's less likely to be impacted by Doja, however you want to say it. But I think Carr is cognizant of what the talking points are of the Trump administration, and I think he'll look hard at ways to make sure that they're properly staffed. But I think that the flip side of that, he has been there for 10, 12 years. He's got a lot of friends. And, they didn't bring in someone with a flamethrower to burn up the agency.
Yeah.
He has got relationships. And I think unlike people who have no connection to the hundreds of people that work there, I think I don't suspect that he's there to get rid of his buddies and his longstanding relationships, and realizes the importance of the staff to get the job done because of the intricacies of how complicated this stuff is. So I don't see Doja having quite as much of an impact on the FCC. But I don't know, Steve and Kevin may have other thoughts.
Yeah, one of the things that I think needs to be discussed is the role of the union in all of this. I think there's going to be a lot of discussions around what this new agency, which isn't even stood up yet, it's sort of a shadow agency at this point, what they can do with respect to union employees that work at the FCC and a whole bunch of other agencies in terms of, forcing them back to a 5-day work week, which will have, which will create attrition within all of the agencies because folks have, settled into a post, I guess we're not really post-COVID, but post-pandemic environment with things like childcare and managing the work-life relationship, and really don't want to go back. So the other point, which Glenn alluded to, is that Commissioner Carr is pretty tight with Elon Musk. He's gone to a launch, post-election launch, and came out in support of Starlink when the FCC majority rejected Starlink's $890 million, give or take, Rural Digital Opportunity Fund application. So, a lot to be seen, but the power dynamics are definitely shifting.
Yeah, I think the only thing I'd add to what Glenn and Steve said, Dario, is, one thing I would flag is that DOJ is kind of it is a unique animal. It's not a government agency. It's outside the government. It's almost like an advisory committee. So what, if any, impact it has specifically on the FCC remains to be seen. The other thing I would add to Glenn's point is that, the FCC is not one of these government agencies that has generally drawn the ire of Republicans. When you look at sort of what's happening at some of these other agencies like the FBI and DOJ and elsewhere, they've been very politicized. And the FCC isn't that. They're a nuts and bolts agency. And I think the fact that, as Glenn noted, the fact that the Commissioner Carr was nominated to be chair indicates that, they're taking the role of the agency very seriously. They're not seeking to restructure or remove the agency.
There we go. Plenty to go back to on what's going to be happening next. But let's look at some of the big topics, not just for changing politics, that have been developing for the last few months. And I've learned about the Chevron doctrine, the 40-year-old Chevron doctrine, that required courts to defer to an agency interpretation for anything that was ambiguous in statute. Now that changing quite dramatically with the Loper Bright Enterprises versus Raimondo, pretty much overtune that doctrine. Now, what are the implications for the FCC here? And did I get it right as an outsider? Is that what happened? So let's see if Kevin can tell me whether I understood it right and whether really is an implications on that.
Yeah, no, I think that's generally a good nutshell overview, Dario. And I'll just say this up front, the impact of the Supreme Court's decision in Loper Bright is hard to overstate. As you referred to the Chevron doctrine. That is a 40-year-old decision Chevron v. NRDC. It's been cited multiple times in appeals of agency orders, and it was a fixture in, administrative law interpretation, if you will. And what Chevron did, like the premise of Chevron, it required courts to give agencies the benefit of the doubt when interpreting ambiguous federal statutes. And so long as the agency's interpretation was reasonable, then, the court upheld the agency's decision. And there was a two-step process in how that was conducted. If the statute was not ambiguous, there's no issue. If the statute was ambiguous, so long as the agency's interpretation was reasonable, then the court would uphold the decision. So what Loper Bright did, Loper Bright sort of flipped the script on that. And what Loper Bright said, it concluded that the reviewing courts, not federal agencies, are the ones tasked with interpreting the meaning of statutes. So, at the end of the day, what does this mean going forward? It means that courts are now going to be in the driver's seat in terms of exercising their independent judgment on whether an agency has acted within its statutory authority. And, under Loper Bright, they can give due respect to the agency's interpretation, but not deference. So it is a seismic shift in, appellate practice and how FCC decisions will be looked at by the courts. One thing I would just add, it's not as if this is a flick of a switch, okay? It's going to take many years for the full extent of Loper Bright to sort of work its way through the courts. But, to be clear, any order that comes out of the FCC that gets appealed is going to be subject to this Loper Bright decision. And it has definitely shifted sort of the balance of power, if you will, on how these agency rules and orders are interpreted.
And in fact, Kevin, we're seeing that in the net neutrality case,
right,
where that was kind of the front and center argument as to whether the FCC, without specific delegation authority, had the ability to change the classification of broadband from an information service, which is a light touch regulatory regime, to a telecommunications service, which has a more heavy-handed common carrier type regulatory regime. So I think that case, which goes back to 2018, when Judge Kavanaugh, now Justice Supreme Court Justice Kavanaugh, signaled that he thought that that net neutrality was a quote major question and required a clear delegation to an agency before it could adopt rules. So that will be an early test case of the FCC's authority, although every case is going to be specific to its facts and specific to the congressional act that did or did not or may have asked the FCC to take some action. So I think we're going to see more of an impetus on Congress trying to be more clear in what they want agencies, not just the FCC, but every agency to do when they pass legislation, so that their delegation can be more clear and survive a challenge like what we saw in the Loper Bright case.
Yeah, I think the only thing I would add is, and I'm going to just sort of follow on Steve's last point, it does in many ways, and not just to communications law, but in any regulatory statutes, does put the burden on Congress to be more clear in what it wants. And, my sort of sarcastic comment would be, yeah, good luck with that, right? I mean, the reality is that Congress struggles with these issues. And I think I think in some ways Congress may regret this change in Chevron because it allowed the agencies some deference and a bit of some latitude because they do have the expertise. I mean, we can talk about technology and communications law, whether it's environmental or energy or nuclear. Do we really want Congress where, these are politicians and lawyers and doctors attempting to write statutes. Now, we all know that it's industry that stands behind this, but I think it may make legislating more complicated and more difficult because we have such far right and far left and center factions on everything these days. So, you know, and I'll just say I don't have an opinion on net neutrality, but I don't think anyone would argue that the FCC doesn't have the authority to classify services. I mean, that's what they do. That's what the FCC is supposed to do. And so whether the issue about whether broadband is one of those services that the FCC should have classified or not, I mean, I think it's going to be every case is now going to get appealed, but frankly, 90% of disputed orders get appealed anyway. And I think given the lack of urgency on the courts, we're going to end up with a lot of muddling going on. And unless stays are issued, we're going to have these issues where we're going to have cases being disputed, rules being disputed, and if they're not stayed, the possibility that they're all going to be undone in 6 to 9 months. So, good luck. Industry, talks about wanting certainty. I think we are looking at 5 years or more of just significant uncertainty. And, if that's what people want, I think that's what they're going to get. And maybe that's where we're at anyway.
And just to add to Glenn's point, and I don't want to beat this to death, but when you look at the Communications Act of 1934 and the 96 Act, they are not models of clarity. And that's just going to introduce, to Glenn's point, this is going to be a very thorny issue as it works its way.
And Glenn, I would like to say that you are probably the only person I know who is neutral on net neutrality. So, congratulations for being stuck in the middle with clowns to the left and jokers to the right.
Steve, I'm a mercenary, not an ideologue.
Here we go. Well, but it looks like the three of you, given what you're telling me with Lupa Wright, will be very, very busy then. It's going to be a very litigious time, it seems to be, for the next few years. Now, what I'm going to be using all of your expertise right now for, because I'm not going to even attempt to define what is JARCSI, which help me out. There is something happening which has got a lot of impact on this industry as well, and it might shape the enforcement for the FCC as well. Who should I rely on this time to help me out?
Kevin.
No volunteers.
All right.
Well,
all right. I'm happy to jump on it. Yeah. JARCSI, one of the big debates is how to pronounce it. JARCSI. I think either's fine. But JARCSI, as I pronounce it, was another Supreme Court decision issued last year that will again profoundly impact the ability of agencies like the FCC to engage in enforcement actions. And what JARCSI involved, it was a case between this individual and the Securities and Exchange Commission, the SEC. And what they concluded was that the defendant had a right to be tried by a jury in an Article III court rather than before an agency's own tribunal. And, long story short, JARCSI was found liable for violating various SEC rules. The SEC imposed a $300,000 civil penalty. And then JARCSI sued in federal court, arguing that the SEC violated his Seventh Amendment rights. And, the Supreme Court's opinion suggests that civil money penalties like those that the FCC imposes are punitive by nature. And because of that, because of the punitive money penalties, that requires an Article 3 process and a jury trial, which the FCC's enforcement framework is not. So, like Loper-Bright, this is going to take some time to play out in the courts. I think Steve mentioned the appeal, the open internet appeal that's relying on Loper-Bright. There's a case in the Fifth Circuit where AT&T has teed up the Jarchese issue for a recent FCC enforcement action on location-based services. So this will have an impact on any agency, including the FCC's ability to pursue enforcement actions. Now, but before the call, we were talking about Jarchese and sort of incoming Chairman Carr's views. He has publicly stated that the FCC must fundamentally reform its enforcement practices. And Commissioner Symington, ever since the issuance of Jarchese, in all subsequent FCC enforcement actions, whether an NAL or forfeiture order, he has dissented from those actions based on the Supreme Court's Jarchese decision. So, that's kind of a high-level overview. Steve, Glenn, welcome colored commentary on that.
No, that was good. And, a couple of things is that, as I understand Jarchese, I'll say it that way for consistency, is that, it applies to cases that are kind of rooted in common law, things like fraud,
right.
Things like, things that, so there's a question as to whether, if you are, I'll give an example, if you've not filed documents with respect to Universal Service Fund contributions. Well, is that the sort of thing that is covered, or is that the sort of thing that is not covered? Not reporting a data breach, is that the sort of thing that is covered or is not recovered? That's the kind of thing we may find out in the Fifth Circuit case. It's also important to note that beyond monetary forfeitures, the FCC, can impose behavioral modifications or enter into consent decrees. In the past, it's been things like conditioning merger approvals. That may not be something that the upcoming FCC would like to do, but if they're stripped of their authority to impose fines, they're going to be limited in the sorts of things they can do to rein in waste, fraud, and abuse and anti-competitive behavior or consumer protection violations. So a lot on the table there that this pending Fifth Circuit may help us learn more about.
I mean, I think the only thing I would add is, the FCC's enforcement, depending on the entity, is if you're a smaller entity, you want to probably get it done quickly without spending a lot on legal fees, so you tend to try to settle things pretty quickly. If you're a larger company and you have other issues before the FCC tends to have leverage because you want them to do things. So the question really becomes is, the entities that are willing to sort of run through the courts on the Jarchese are going to be ones that, potentially have money to sort of support the legal fight, and, that have otherwise not been willing to play ball with the FCC during the enforcement process. Because I would say, probably 95% of the letters of inquiry or a lot of these are just minor infractions, which, you're going to settle it for $2,000 because you forgot to file a report, versus I'm going to, spend $100,000 on legal fees trying to make a point. So the question really becomes at an FCC level, because you may need the agency to do things for you. How much are you willing to fight it on particularly smaller amounts? Now, if it's a $50 million forfeiture on a data breach issue, and you're AT&T, maybe you want to spend the money on legal fees. But I think at least at the FCC, it's going to be a bit more surgical as to the type of cases where the defendants are going to want to spend the money to actually, see whether Jarchese matters or not.
There we go. Now, let me move the conversation to some of the topics that might be familiar and easier for me to pronounce. That's great. Such as the TCPA or robocall. Now, this is where we've seen a lot of a discussion is going on for quite a while. But in the case of TCPA, we have a big deadline coming on January 27th, as the TCPA was amended to require a prior written consent for a single seller. You cannot go for massive sign up to multiple marketing arms in one place. Now, this means that a lot of things marketing partners will have to amend and adjust, and robocall, everything happening, still shaking, and so on. Now, what's your view on those? Are we looking at some additional changes, or how is the market for consent and the regulations for consent changing in the USA?
Go ahead.
Stephen, you started. I will give it to you straight away.
No, do you want to take that, Steve? Or
No, please go.
I'm happy to jump on that. Yeah, Dario, TCPA front and center. As you noted, we've got this rule, the one-to-one consent rule, going into effect on January 27th. 2025, and as you noted, the rule mandates that consent must be provided for each individual seller or brand, rather than allowing a single consent to apply to multiple telemarketers. As far as sort of where we go from here, at least on that point, that order is currently under appeal, I believe, in, Glenn, keep me honest here, the 11th Circuit.
Yep.
Oral arguments are scheduled for next week, December 18th. And, that's obviously going to have a significant impact depending on where the court lands in that appeal. One other item on the TCPA front that I also just want to flag is the FCC's order from, I think it was this year, I think February 2024. This is the revocation order. That rule, the consent revocation rule, that goes into effect April 11th, 2025. And, in my mind, that thing's a sleeping giant. That's going to be quite disruptive to industry, I think. And, just as an overview, the FCC in its order found that, a consumer can withdraw consent by using specific words like stop, quit, revoke, etc. Those constitute per se reasonable means to revoke consent. But the FCC went further and said, that does not preclude the use of other words or phrases to revoke consent. And the burden is going to be on the message sender to, determine whether that was consent was revoked in a reasonable manner. And the other thing I would flag on that order or on that rule that'll go into effect early next year is that the FCC basically said that consumers can use other methods such as voicemail or mail or email to revoke consent. So, that's a sleeper issue. I know, a lot of stakeholders in the MEF community are aware of that. So, it's going to be a big year ahead. We've got the appeal. The only other thing I would add on TCPA, is whether there's going to be some type of appetite on the Hill, given that we now have, a Republican Senate, a Republican House, and a Republican White House to perhaps do some targeted changes to the TCPA. That's something industry has certainly been clamoring for. So we'll see what happens there. And then, Glenn, Steve, I don't know if you have anything to add on that.
No, it's a great point, Kevin. And I think the other things to just keep your eyes open to is, the FTC now is sort of weighed in and expects that you're going to can't be able to cancel services as easily as you signed up for services. So I think sellers just need to be aware of the new framework and the landscape out there that kind of tends now to just suggest that it may be more difficult to tie customers up under longer term deals. And there just may be a bit more empathy on that. And I'm not even sure that this is really, an R versus D issue. I mean, I think there have been so many complaints regarding messaging and calls. So I think the other area that we're going to see, continued advocacy and enforcement is in the robocall area. The FCC a couple of days ago notified 2,411 entities that are listed in the robocall mitigation database that their filings are insufficient, and that if they don't correct them within the next number of months, they will be thrown out of the RMD. And if you are a voice service provider, what that means is anyone in the RMD that follows the law should not be accepting traffic from you. Now, when you look at the order, it's a bit, wow, that's amazing. I think what kind of got lost in some of the reporting was all of those entities had been notified previously that they were deficient. And the fact that none of them fixed the problem suggests you kind of wonder how real these entities are in the first place. But the idea is that, if you're a voice service provider, you have got to be sort of on top of the know your customer obligations. You've got to be on top of what's going on in the RMD. You've got to stay on top of, people on the do not call list. You've got to, know the reassigned number database. The number of traps that are now out there for text messaging companies and voice service providers are plentiful. Yeah. And really do need to be sort of on top of the regulatory, the evolving regulatory environment, because it is easy to mess up at this point.
And Glenn, like one thing I'll add quickly on what you said, for anybody listening to this webinar now or watching it later, pull up that list, because, the one thing I would disagree a little with Glenn on, not all the providers on there are, many are shady bad actors that are clearly shell companies. But I perused the list yesterday, and there are legitimate established companies that I think, just forgot that they needed to update their RMD. The email address they put in the RMD was an employee that has since left the company. So check that list. Be like Santa, check it twice.
Yeah, we came across one company on the list that had actually filed twice, and they couldn't figure out who filed the second one or the one that was listed on the list. So, that's a pretty easy fix. So, I mean, it's everything from that to, more serious things and fly-by-night organizations. But agree 100%. Look over the list, look it over twice, look under any name that your company or multiple names that your company might be registered under, so that you make sure you do it. Because there's an obligation not just to update the RMD, but also to notify the Enforcement Bureau. Yeah. And, some folks would just think, oh, just press the button and I'm done. But you got to go a little bit further and in some cases provide an explanation. So happy for the Enforcement Bureau to be, getting all that work.
Great. Let me move to something else. Usually we might be touching upon spectrum. I understand from you, Volvo, there's not a huge amount of spectrum discussion, always there. But more interesting potentially is a broadband. Fundings are cousin from the fixed side rather than the mobile ecosystem forum. And here specifically two topics that have been highlighted. One is a USF, Universal Service Fund, as well as the Broadband Equity Access and Deployment, a program which is worth 42 billion. So it's a couple of coins here and there. Big things, big changes. Any strong views from our panel?
I think Steve should start.
Well, I'll take this one. So there's kind of two aspects of this, universal service and the BEAD program. Let me take the second one first, and then we can come back and talk about universal service. So the BEAD program is a $42.5 billion program that was established by the Infrastructure Investment and Jobs Act, sometimes referred to as the bipartisan infrastructure law, because I think a couple of Republicans voted for it. And it's a massive piece of legislation that covers everything, but there's a small piece of it that is set aside to establish the Broadband Equity Access and Deployment Program, otherwise known as BEAD. The way that this program works is that the money is in the US Treasury, but it's provided to the states based on some formula that takes into account the number of unserved locations and underserved locations they have. And then the states are supposed to administer these programs with a lot of oversight between the two. So no money has been doled out since the act passed in 2020, well, more than 1,000 days ago, about 3 years ago. And a lot of it has to do with standing up the program. A lot of states, probably half of them, didn't even have a broadband office and had never administered a broadband funding program before. And of the half that did, maybe about half of those were doing it the right way and half were doing it not the right way. So it was a massive undertaking with a lot of overhead, and I think a lot of it was backlash to some of the perceived abuses in the FCC's RDOF program, the Rural Digital Opportunity Fund. So this particular program was put in an executive agency, the Department of Commerce, as opposed to an independent one, the FCC. It has a very decided fiber priority, and that's something that is drawing fire from Senator Cruz and a number of Republicans on the Hill, that by prioritizing fiber so heavily, there will still be thousands, if not millions, of locations at the end of the day that are not funded with satellite or with fixed wireless technologies that can achieve the same speeds, although they are not fiber. They were deemed to be not reliable technologies. They are more affordable to deploy by some estimations. And the thought is that the government's money could go further if it were more technology neutral. That is something I think we're going to see change in the BEAD program. The interesting part about all this is that some of the states have already begun to implement their application process. And one state, Louisiana, has already made a determination as to who's going to get the money and how much. So, and from what I understand, Louisiana is getting ready to certify and get the NTIA administrators sign off, and that will release the funding for that particular state. What's going to happen with other states, and whether there's going to be a total reset, an on-the-go fix, or just modest changes around the margins to eliminate some of the ornaments on the tree, things like required to work with labor unions, or having a cybersecurity plan, or making sure that your network is climate resilient, and a lot of other things that are in the program. That all remains to be seen, but I think that's going to be a real emphasis over certainly the next 6 months and the years to follow as to what happens with the BEAD program, what changes, what doesn't change, and ultimately where consumers are able to have better access to better broadband.
Kevin or Glenn, anything to add on the?
Well, I mean, less about BEAD, but again, this is the cynic in me personally. I love how the communications industry rails against regulation, but they love to get government money. I mean, it really is a bit, I think, hypocritical that, anybody who argues that, government shouldn't be involved in certain aspects of our lives and we need to privatize certain things. It is funny that, those are the first people standing in line with their hands out when it comes out to build these out. But I recognize that in these communities, obviously the capitalist market is not working, right? Otherwise, they would have built out. These are low density areas. These are geographically complicated areas. I mean, I hate to say maybe these are poor areas, right? It goes to the equity issue. So I just think it's a bit, I think it's a bit hypocritical of, give me the money, but don't regulate me. So I'll leave it with that. But I think it's important that we only got a few minutes, but I tend to not represent the people building out the broadband networks, but the people, that contribute to the Universal Service Fund, which helps, broadband in high cost areas, helps poorer people have access to communications. There we have got, a glass ceiling that may be shattered soon. We've got a contribution a process that has now been called into question by one court. Two courts have upheld it. The case is now going to go to the Supreme Court. It's an $8 billion fund, which in the scheme of what we talk about in Washington is actually pretty small. But the question really becomes is whether the process by which the FCC collects those monies is constitutional, whether it's sustainable. It is a huge burden on companies that buy communication services because the revenue side has been dwindling while the expense side has been relatively flat. And so if you are a purchaser of communication services in the US, you're seeing almost a 38.5% tax on your bill to fund these public purpose programs. Now, you can come out where you want about things like Lifeline and E-rate, which are potentially important, but there is some argument and maybe going to get some traction that maybe these funds should be coming from general revenues. There's been a push from the larger carriers for years to let these get funded without the communications, without the FCC involvement. There's also conversations around whether there should be an expansion of the entities that pay into the fund to include tech platforms. The statute as written now requires that it be telecommunications carriers and VoIP providers and wireless carriers now, do the bulk of contributing to support the fund, and whether there's an appetite for Congress to expand the payers into the fund to include, quote unquote, tech platforms is going to be an interesting fight, or whether they're going to take it into a different direction and try to get the $8 billion from general allocations, which the entities that receive the monies really oppose because they don't want the uncertainty. So I think that is a huge issue for industry broadly. And it's, it is going to go before the Supreme Court because we have appellate courts that have taken different positions on the constitutionality. But that is one I am just really curious to see how it plays out, or whether the Congress or the FCC tries to fix this by making changes to the program before the Supreme Court can rule.
So on the Supreme Court case, the clever segue, Glenn, there are questions as to whether the FCC has the authority to collect. You used the word tax, and I smiled because that's really at the heart of the case as to whether universal service contributions are a tax or whether they're a fee. The second issue is whether an agency such as the Universal Service Administrative Company can be tasked with collecting those taxes, since they are not a federal agency and don't have taxing authority, and neither does the FCC. So one of the issues that's come up is the question of mootness, and that is, whether the litigants in this case should have asked the FCC to stay or to prevent that, or to not require them to contribute for a particular quarter, and whether that is critical to their case and dispositive of the case. And that could be a way for the Supreme Court to be looking at a way not to deal with the merits. Another way to look at this is that, maybe the Supreme Court will decide, and they will decide that okay, the FCC, this is a contribution, it's not a tax, but this whole USAC thing kind of bothers us and kind of throw it into chaos. And the third option is that the Supreme Court says, you know what, this is a tax, and you guys figure it out later. And Congress has been looking at reforming universal service, and Glenn talked about the choice between contributions versus appropriations, and there are pros and cons to each of those. What if an appropriation doesn't pass the following year or the year after that? How do you pay for everything going forward without the assurance of an ongoing support mechanism? So this will be fascinating to look at, and I think when we do this again next year, we can take a look back and see how things played out.
Time is almost running out, but I'm going to ask you two telegraphic questions. The first one is, we heard shock horror, somebody is neutral on net neutrality. But Kevin, out of your crystal ball, what do you think is going to happen on net neutrality? You've got a minute.
Well, I think it's in that appeal is in the Fifth Circuit, which is a very conservative appellate court. My sense is, like, if I had to look in the crystal ball, I think that the court would likely be receptive to the arguments that are being made there. But I think regardless of how, well, it does depend on how the court rules, but with Republican FCC, once they get to a majority, they'll be able to address that issue, if the court were to release an unfavorable or, a position upholding net neutrality.
Here we go. And another very fast questions, potentially one worth billions of dollars. Stephen, if I may ask you, what's the impact of all of these in terms of M&A? Are we going to see a lift up? Are people ready to open their wallets?
I'm going to give you the typical lawyer answer, which is it depends. There's a lot. If you can, sort through the uncertainty and ascribe value to that and, hedge your bets. I think there are a lot of opportunities, especially on the broadband carrier side, because there will be deployment, whether it's under BEAD, whether it's under some state program. I think that's going to continue to roll out. And in fact, just the threat of BEAD has sort of caused some investors to jump into the space and promote broadband expansion for smaller carriers. You're seeing some of the private equity firms, develop a broader portfolio in broadband carriers. And I think in a generally in a Republican administration, the general thought is that it is going to be more open to M&A and more investor friendly. We have the courts to contend with, and we have uncertainty in the marketplace with respect to a lot of the issues we've talked about: universal service reform, what happens to the BEAD program, what priorities will be set out by Commissioner Carr, and what Congress chooses to be important. I do think that the issue of 2025 is going to be cybersecurity. I think that's going to be a huge issue as we see more and more state actors trying to use our networks to engage in espionage for whatever purpose they deem. And I think that's going to be a huge regulatory issue, congressional issue, and maybe even some sort of an investment issue.
Yeah, I would just jump in real quick on that. I think Steve's 100% right. I think it's going to matter too where the money's coming from. To the extent that these dollars, a lot of these private equity guys have funds that include money from, actors in states and countries and government entities, which may or may not be favored by the incoming administration. So I think there'll be a lot of activity. I'm not sure I agree 100% that the review is going to be any less than it was before. I think there are favored industries and less favored industries. I think there's a lot of skepticism about certain entities, and particularly from the tech world. So I agree. I think there should be more activity, but to the extent that this money, is from foreign actors, there is still a review process that goes even beyond the FCC that is going to make this, particularly if there's government funds from other countries that are going to be heavily scrutinized before these deals get approved.
Yeah.
100%.
We had lots of questions, and we didn't have time to asking too much to our public out there. But fear not, comes only in a few months, and in April we're going to be sitting next to each other. I hope with at least quite a few of you, if not all of you, please, talking at the Leadership Forum for MEF in Miami on April the 1st. So we might already check whether some of your vision, some of your expectations are on track or not. For the time being, it's exactly us on the hour, so I think it is time for me to say a big thank you to Stephan Corin, the attorney from Lerman Senter, Glenn Richards from Dickinson Wright, and Kevin Rupy from Wiley. Thank you very much. Thanks for being with us, and until the next time.